Fast and good, right,
Oh,
Kristen?
yeah.
She's fast and good.
Yep.
We are officially live. Thank you for joining us. Got a wonderful panel here today. Today's topic is going to be job loss. We talked about the vocational side of that issue last week, and this week we're going to focus on the procedural side and I guess the math behind the methodology. And I have the pleasure of I've got a great panel here today. And again, my name's David Bilodeau. I'm a family law attorney in Newton, Massachusetts. And I have the pleasure of being joined by Honorable Judge Susan Ricci, who is now retired probate and family court judge, but she is in private practice now, focusing her attention on dispute resolution, master work, and also case conciliations and the like. We also have family law attorney Kristen Dobrel, who's a partner at Verrill Dana, and her practice focuses on family law. And we also have financial expert Susan Miller, CPA. She's the managing director and senior wealth advisor at the Colony Group. Thank you very much, ladies, for joining me today.
Thank you for having us.
Thank you.
Thank you. Kindness to come on and talk. So one of the things that I think has come up, probably all seen, that I wanted, the focus of this panel to be on today is a lot, unemployment is obviously much higher now than it's been in a long time, and there are a lot of people that are losing their jobs, and it does impact these family law cases that we have, whether it be paternity or divorce. And in my own practice, I know I've seen, I get calls from clients, I've either lost my job, I'm about to lose my job, my pay's been reduced. What do we do? Or the other side of it, I get the call from the recipient saying, so-and-so who's been paying me, my ex-spouse or ex-partner, is telling me they don't have to pay me anymore because of COVID-19. What do I do? So I think it's a big issue. Why don't we take a minute and at least just talk about what's happening in the court and what folks' experiences. I mean, I think one of the biggest problems with this particular issue is because of the closures to the public, it's not getting a lot of attention in front of judges. And I think that's actually probably compounding the problem. At least that's in my practice. I'm not having much luck getting modifications in, contempts. Kristen, are you having the same sort of, are you seeing the same thing in your practice?
Yeah, we're also struggling with a lot of timing issues, right? And getting summonses, for example, that's been really hard. It's been a delay, and there's an impact, a material impact in terms of getting that summons served for retroactivity purposes, and it's difficult. Access to the court in all regards has been slighted somewhat.
Yeah, Judge, what have you heard about the issues with the summons? I know you're very connected in the community. What are people saying about the courts doing in terms of trying to move the summonses along, things like that?
I think what I am just hearing anecdotally is that sometimes it's taking a month from when the complaint gets filed until a summons, and that month is so important for retroactivity. And so I think just a very nice email to the judicial case manager or whatever, reminding, because that is one of the very few summons that are so important. I guess in a divorce summons would of course be important because of the automatic restraining order as well. But I think for retroactivity, when you're seeking to modify something backwards that was totally unexpected, that is so important to get service of that. And so I think that when you speak to judges, and I know that you all do, or judicial case managers, that you remind them that it's been a problem. I don't even, somebody files something and then it just goes right into cyber world. And I don't think that the judges know. I don't think they have any idea of when a modification complaint is filed and a summons is issued. So I don't think that anybody would be upset if a friendly reminder, email or telephone call or left a message saying it's really important to get a summons. We won't bother you for a while, but I at least need to toll that and to start that process.
Yeah. I mean, one of the things I'm interested in your thoughts, in talking to some judges just privately, I mean, I do get the sense, I think everyone's everyone's obviously very aware of what's going on. And I think judges, obviously they're bound by, certain procedures and the such, but I think they're very mindful about what's going on and in terms of people getting summonses late. And, I don't know what the actual impact on a case is going to be, but I think the judges are paying attention to this stuff, and they know that it's not happening as quickly as it normally does.
Right. There's no way that a judge ever knows until something comes into the courtroom or hits their desk what's been filed, right? How do we know how many modifications? That's really a registry issue of accepting filings, making sure they're fined, accepting them and docketing. Judges don't know that. How do they know when something is filed? Until it comes into your courtroom or gets on your list, a judge would have no way of knowing that. I don't know if there would ever be able to allow retroactivity without service.
Right.
That maybe because I have not heard that would ever happen, but I don't think a reminder on that particular, or even a complaint for divorce if you needed an automatic restraining order. I can't imagine summons are going out much quicker on that, right, than they are on the other. And it's just a disconnect between the filing in the registry and when a judge hears about it. A judge would not be mindful of that at all. So I don't think that a call to whomever, I know that each judge has a contact person, judicial case manager or session clerk. I don't think an email or a call is inappropriate. Of course, my 49 former colleagues are not going to like that I'm saying this, but I would want to know that. I would want to know if people were not able to at least, toll for the retroactivity in 30 days. That's a big deal.
I mean, I'm sure Kristen used to do this too, but I would go to the court, or I'd send, one of my staff members, and I just say, you're going to sit there and wait for the summons.
Yep.
And then so that we have it right away. And I'm sure that drove, the people at the counter crazy, but that's how I always did it. And you can't even walk to the courthouse, right? There's nowhere to go.
There's no way to get it. Right.
So, it's a pretty tough issue. I mean, one of the things that I think is a really tricky problem here is, and I've talked to some of you privately about this. I really do think we're sort of opening the door to a number of case issues because we can't deal with these cases quickly. Someone loses their job, and then they're gonna try and run into, you can't run into court and get it rectified. But with what's going on, COVID, maybe they get their job back, or maybe they get some sort of subsidy, or, you're sort of signing yourself up for a couple cases instead of just one.
Right.
I don't have a good answer as to how to solve that problem, but I think the best answer is to go to try and resolve your case out of court, I guess.
Right.
Yeah, I was just going to say, I mean, so many times as practitioners, I always say to clients, who the other side retains is critical. Your case can look very, very differently depending on who's on the other side. And to be able to sit down and have relationships with folks on the other side and say, look, let's say, I represent a husband, right? My guy just got furloughed, right? The expectation is that he's going to be back full-time, fully employed, I don't know, by August. Can we work something out? And then come August, when he's, operating on all cylinders, we'll automatically kick it back up to whatever the pre-existing obligation was, right? Are you able to have your client be reasonable? And, I mentioned to David that I have a client who, does very well. He's in the practice of medicine, and he does primarily elective surgeries. So guess what doesn't happen during a global pandemic?
Yeah.
Elective surgeries, so that there's room for COVID patients. So, getting calls from clients in those sort of circumstances where, on paper, they make great money, but are you going to get sympathy from a judge when, you try to say, well, instead of making, I don't know, pick a number, $1 million a year, he may make $800,000 a year, reaching out to another side and say, it's possible that, in circumstances like this, you get a call from, the head honcho or head woman at a company or a hospital and says, we're asking that everyone at your level voluntarily take a pay cut. We don't want to have to lay people off. We don't want to have to furlough people. Are you willing to voluntarily take a reduction? And to have to say to a client, either you don't do it and you risk being the jerk who's the only one in this group who doesn't want to, do the right thing, if you will. Or your only other option is to take it, but you're not going to pay less because technically it's a voluntary reduction. And I can't advise you to just automatically cut your existing obligation. So the question in that case, kind of come full circle, is could you pick up the phone and call whoever represents the recipient and say, look, during this time, is it, could you work something out to, instead of, be paying 50 grand a month in support, is 40 grand for a couple months, is that okay? Sometimes it's not even worth the phone call because you know the answer, but the hope is that maybe there's an openness to have everyone kind of come together and say, could we work something out? And then once this situation resolves itself, we'll get back on track.
Yeah, I mean, I entered a STIP very similar to that recently, same type of scenario. And I said there was some resistance, and I said, well, you want to go to court and spend $50,000, or do you want to take a hit for a couple months and see what happens? And I mean, luckily they bit, but that's a real problem if you have someone that really doesn't care about going to court, doesn't have a problem, taking you to task. Yeah.
Right. Yeah.
I'm wondering, I want to talk about because I actually think, I'm curious what everyone thinks, but I think there's a difference in my mind between the child support versus the modification on alimony. But while we're here, let me bring this up before I forget. Kristen, have you done any Rule 78 requests on support issues?
I have not done any on support issues so far. I've done them on discovery related issues, kind of complex issues, but not support related, no.
Judge, what do you think about someone submitting a Rule 78 request on, a request to suspend support because a job's been lost?
I think that's actually a good way to get it before the court. I hadn't thought about that. I was thinking more about motions for relief from judgment, where there was a property division that you're unable to meet now because the value is nowhere. You did a dollar value as opposed to a percentage or a number of shares or whatever. I think Rule 78 is underused, and I think the court really likes to have things in writing that they can take the time to sit down and to review. I think that's actually an excellent remedy that I hadn't thought about. I was thinking more about countervailing equities. If you had surviving language as to spousal support, of course, you can't survive child support. But I was thinking of some of the surviving issues that would COVID be enough to rise to countervailing equities? I think it's a very decent argument. I think it's a fair argument to make, because some people cannot do the property division anymore, cannot do the alimony anymore. And I don't know with surviving how else you're going to get around that, except maybe a motion for relief, but more probable than not countervailing equities. I think that it rises to that. It's, one of the pieces, and I want to hear from Susan Miller, because I think she has, as a neutral, has so much to say and help us with, but it's not just losing income as Kristen was suggesting, but you may lose your medical insurance, which can be a fortune, right? Or your medical insurance can go up, your medical insurance can go down. You can lose your daycare, right? Or you don't have to pay daycare anymore, but that was part of the calculations for child support guidelines. Yeah. So daycare is a huge portion of that. So if you're not having daycare, not that the parents don't want, I don't know how they're staying home teaching their kids and
I know.
working, but not even with a loss of job, but just other changes of circumstance that I've been thinking about, that it might be daycare, it may be that I have to stay home because school is not open and so I have to stay home. So that, I guess, is a voluntary, like what Kristen is suggesting. It might be voluntary that I can't work, but what else am I going to do? Childcare hasn't been open. I know that it's slowly reopening, certainly not adequately for parents that need to leave the home and go to do surgery, right?
Yep.
So I think there are other changes of circumstance which are valid, not just a total loss of a job and unemployment, that we need to think about and be helping our clients with.
Yeah, I think, David, the one thing I would add about Rule 78, and I don't have it in front of me, so don't quote me on this, but I think a lot of practitioners are running into getting an agreement to submit issues via Rule 78, because I believe there has to be a STIP signed.
Well, right. So the
And
other,
if it's in your interest to not move the case forward, the other lawyer's not going to be able to, you can't submit it absent an agreement.
You're absolutely right. What I just did in a case, it's a child support case where there was an emancipation. It had actually had nothing to do with COVID, but I think it might be applicable. And I did a request for summary judgment on the basis of there was no facts in dispute. The kid turned 23. There wasn't, everyone knows what the incomes were. The other side was just refusing to agree to the recalculation, and I just wanted someone to do it. So I don't actually know if that's going to get accepted, but it was the same situation. I couldn't do the Rule 78 because the other side was like, well, I'm not doing anything. You just have to keep paying me or you're in contempt. And I said, well, we'll see what happens. We'll see about that. So I don't know if the court's gonna.
That will be interesting. The contempt piece will be interesting because, right, the recipients are going to go in, of course, saying, I'm not receiving child support. And if there's an inability to pay, it's good. That will be an onslaught for the poor judges. I can't imagine how many contempts are being filed and will be backed up. That's just going to be huge.
Yep.
Yeah. I mean, turning to the actual, methodology, Susan, have you been, obviously changing gears a bit, but since January 1, we haven't had tax deductible alimony. So what are people doing to come up with a percentage that works against the statute? The statute says 30 to 35%, but 30 to 35% is on someone's gross,
Right.
when they're paying out of their net, can be like 50 or 60 for something insane.
Right.
What are people doing to sort that out?
So that's a good question. And of course, that's totally non-COVID related, right? So COVID brings a whole different piece that you guys have already touched on a little bit, needs and different, temporary need for right now and everything. But in terms of just that piece of it, the alimony piece, that what I do when the clients come to me is I literally show them what the old calculation is. And then I prepare it. I say, this is what it would be if it were still taxable. This is what it is now as non-taxable, as in terms of the parties sharing the same proportion of the after-tax income. So if it was a 57-43 split before, it's a 57-43 split after, but instead of getting, say, 32.5 or 35% of it, you're getting 24, 26, in higher income cases, 22% of it. So that a lot of people, we're still at the point, it's new enough that a lot of the clients are saying, well, wait a second. And people start talking 20 or 26%. I mean, what's that range? How do you come up with that range? So a lot of clients I'm finding really like having a methodology to say, okay, so it was this, it's going to this. So that's how I start in terms of showing them to do that conversion, basically.
But it's not really a fixed scale, a fixed percentage,
No.
A range of like 25 to 28, doesn't really work.
No, that's right. It's really not. And a lot of it does depend upon what the incomes are, right? Because for higher incomes, the percentage is going to be lower based on because of the taxes and because of the income and how it splits out. So it's not. But what I find is most people are okay if you show them a methodology. This is what it was. They understood that. This is what it is, and they tend to be okay with that. I think a lot of people have a problem with just pulling a number out of the air and saying, and then of course I know we all get the question, well, I thought it was just a formula that we all just stuck in, well, isn't that the way this works? So a lot of clients are disappointed when they find out that's sort of not the way it works.
Yeah, I mean, I actually think this is highly relevant, right? Especially right now, because it's harder to settle cases. And I mean, this was one of the ways that we settled cases, having that deduction. And now that we don't have the deduction, on top of the fact that cases are even harder to settle right now with COVID, you have even less option, less tools on your utility belt.
You've gone from a win-win to a lose-lose, and nobody likes that. It was one of the few areas in the tax law between, two parties in any event that was a win-win. And now it's a complete lose-lose. So.
And how does this sync up against the child support? Back when, what I used to do all the time was an unallocated order instead of dealing with the two and how do people sort out which one is right now?
Well, to a certain extent, it sort of depends on what the goals are. A lot of people are still saying, well, we'll do child support on the first 250. And because that is formulaic, right? That just goes right in there. And then we'll do alimony, non-taxable alimony on the amount over that. But then if it isn't a case that would go, the incomes are not above that, then the question is, you start having people say, well, I have one client right now who's saying, I would rather do non-taxable alimony and keep it. They've got 5 children, and he does not want it to decline as the children emancipate. He doesn't just want to run the child support guidelines. So he's trying to be sort of magnanimous and try to help make sure that everybody's okay. So they're choosing actually not to do child support. He's going to be doing an amount greater than that, just to keep it sort of a level amount. But that's one thing. Another is, for definitions of income, right? What is the definition of income for purposes of alimony versus versus child support? Unemployment compensation, right? That is. I'm working with a couple right now where he's lost his job, and it is his definition of income is specifically earned income. Well, the IRS, as you know, the unemployment compensation, even though you do pay taxes on it, is not technically included in the definition of earned income. But for alimony purposes, but I believe, well, please help me out here. Is it included for purposes of child support?
Great question. The
Um,
guidelines in front of me.
I'm gonna
Unemployment
defer to the judge.
Yeah, I think it is. Yeah.
I think
I don't have
thought
it in
was
front of me.
too.
Yeah,
I have it
think
right in
is.
front of me.
Which is an excellent drafting tip, Susan, right? I think to all the attorneys that are on board listening to us, that's, I always say, because the days of W-2 employees well before COVID have gone, the compensation packages and how people get paid is insane. Nobody just gets,
That's right.
40,000 divided by 52 or 100,000 divided by 52. And, they wait and they do it in December, but they don't get it for 4 more. It's crazy. Right. So it's so important. The drafting, or what I saw in the courtroom that came back, was just what you're saying. That's not earned income. I don't have to include it because the definition is earned. And I think for drafting that we all need to be so careful when we draft these agreements, or even in proposed judgments to the court, as to what to include as far as the source of income from when you start doing percentages or whatever it is.
Right. Another one right now is the PPP,
Well, that's what I was
forgivable
just gonna ask.
loan.
Yeah, I was just gonna ask you about that.
Yeah, so that is going to be a very, God willing, it'll be a one-time thing. We won't be looking at this, doing this again next year, but who knows? But then do you include it for purposes, is it included as income for purposes of support so that the recipient gets a percentage of it? Do you say that it was, goes to the family, you split it? I mean, that is a real question. It's technically, hopefully, most people that I've spoken to are taking out loans and have figured out how to spend them so they don't have to pay them back. But if somebody does have to pay a portion of it back, then what do you do about that, right? Because
How do you recapture
Well, I
that?
think the loan part is, I mean, at least for me, I mean, I'm interested what everyone else thinks, but for me, the loan part's the easy part. Someone takes a loan and, I mean, businesses often have, lines of credit or whatever. So, if you took a loan, that's obviously not income if you have a line of credit. But I think for me, the real question is this forgiveness thing. I mean, the way I've been looking at it with clients who have, an S Corp or a C Corp, I think, and I'm curious what you think, it strikes me that the simplest way to do it is to just, if there's $100,000 of forgiveness, eliminate $100,000 of expenses off the Schedule C or whatever, or off the P&L, I guess. So then that would potentially increase the net revenue, depending on how that, that's the other issue is you've got clients you've got companies who are making the same amount of money they always make. They just got this loan because of this, I think the loan was originally intended to bootstrap companies that weren't doing well, but I think there's plenty that are doing perfectly normal and still getting the forgiveness.
that's right.
Even when persons are able to, if you own a business, you're able to go back to work. We know that because of the restrictions or because of the guidelines, that you're not going to obviously open your restaurant or open your dental practice or whatever 100%. So your volume is going to be down, number one. Also, the cost of continuing to keep that open, if you are a dentist, if you are a physician, if you are a restaurant owner, I cannot imagine how much all of that equipment costs to have. I mean, even a nail salon or something which you would not think would be high income, right? But they have to put, the plastic or the lucite, every grocery store, the cost of reopening is another issue that's going to impact income that I think we all need to be thinking about and arguing for if you have to go into court. It's not just, yes, I'm going to, yeah, we can open and we can only do 25% and go what's 25% of last year's income? That's not true because your expenses are going to I would imagine, have to be crazy high to buy the PPE, to
Right.
whatever it is, the extra, even the takeout with the extra packaging. I mean, even something so simple and a little not so simple, but as in a restaurant, everything is more now. Everything costs more.
What do you think about that though, Judge? I mean, if you've got, let's say there's a 50 grand buy-in to get all this new equipment, but then you're done. So you get on your tax return, I'm guessing you're going to get some sort of deduction for 2020, but looking, prospectively on it, those expenses aren't going to exist in the ledger the following year. So what do you think the right way to look at that is when you're calculating what a support should be?
Well, isn't that, I mean, that's the problem where everybody's facing on everything is the unknown is that
Right.
When does 25% become 50%? And when are you able to open and earn 75% or whatever? So, courts do not favor temporary orders on modification because you want closure. You don't want it when you keep a case open too long. All it does is encourage people to bring more and more motions, and you should go in, prove your case, get a judgment, and everybody rely upon it. Also, the appeals period is very, the ability to appeal if it's only a temporary order is very, very limited. So procedurally, those are things that attorneys have to be thinking about all the time. But I can't imagine that the court, I don't know. Would you just sort of depreciate it out over a period of time as you normally would depreciation with any type of equipment?
I mean, that's
And
one thing you
business?
could do, because there will be, I'm virtually certain, certainly though, what's called the Section 179 depreciation deduction, which means that up to a certain limit, you can take it all in 1 year. But then you take a look at what it is and, does that make sense? But isn't that the flip side of that too, is the needs, right? Because, for example, Judge, you talked about childcare. So that right now, you don't have the ability to even pay for it because it's not open. But going forward, presumably that's going to go back in there. So this concept of how long we look at any one of these issues as being, a fair representation of a person's or a family's financial situation, I think is extremely tricky.
Even in business valuations, often business valuations contain,
Right.
Susan, correct me if I'm wrong, but one of the spouse's incomes and whether they're overpaid, underpaid, write off certain business expenses, which are personal. We all hear that in the courtroom all the time. But if their income is really lower, it is going to then impact the business valuation.
Absolutely. That's right. And that's in a recent business valuation, the first point that the business valuation expert made was this was done as of 12/31/19. This was pre-COVID.
Yeah.
It's, and then you go from there, right?
Yeah.
Because it's almost every business in some way or another has been or is being impacted. Some people have gone back, but as you say, a lot of things are not. I can't think of an industry, if somebody can let me know, that hasn't had some sort of an impact, an ongoing impact.
Right.
And there are a number of articles came out today, if you've seen them, about the fact that unemployment is going to be grim. This is not going away anytime soon. So I think these are the issues that we're talking about are going to be issues that unfortunately are probably going to be around for a while. I think the concept of the V-shaped recovery is dead. We may be looking at an L-shaped recovery. It's just hard to say.
I'm really curious what the panel thinks about this issue, which is, I think that in thinking about these cases for my own clients, I think ability to pay is more important than ever now, which is when I say that, what I mean is, someone might have lost their job, but then the next question we all ask is, well, what resources are still available to meet that support obligation and for what period of time? Recently there's been a shift in crafting, a support order. We've looked at the recipient's need. I wonder if now we're going to start looking at the payor's need, because we need to look at the pool of resources that the recipient, or that the payor rather, has available, and that that must call into question that person's expenses as well. Which normally if I have the payor as my client, I'm just like, oh well, I don't really care what that person's expenses are. Never really spent a lot of time thinking about it. I'm wondering if we're going to have to start thinking about that more.
Yes, right. That's actually very interesting. You're right, because there's only so much. Even if you're able to go back, if and when you're able to go back, how long until you can go up to the prior lifestyle if it's a divorce, right? I mean, if you're doing needs and lifestyle, and really needs are very different now. Your needs may be the same, but your ability to pay for those needs, pay your mortgage first, but maybe you don't have the needs of travel and the needs of,
Right.
very, very.
Daycare.
Yeah, right. Yeah, but
that's an actual need.
Yeah, but it is for people to go back to work.
Me.
It really is. Or camp this summer, whatever it is.
Yeah.
People aren't able, I think everybody's kids crawling all over them during Zooms is the cutest thing I've ever seen. No, I do. I love to see it, except I don't think you really want your kids exposed during hearings with everybody in the world seeing them, right? I mean, hopefully temporary. And what if someone is offered a job, offered to go back, the job, and they refuse to go back because
Right.
many say I'm making more on unemployment. I understand that, but also because I'm afraid to go back. I have
Nah,
my
that's a
mother
great
lived, my
question.
older mother living
Yes.
it up. You know,
And-
is a refusal to go back.
Have you run into that at all, Kristen?
I have not run into that issue particularly, but I think, obviously all that we're discussing is making it crystal clear why David and I are having such a struggle probably trying to settle cases these days, because it's really difficult to settle cases when there's such uncertainty and predictability about what the future will look like.
Yeah.
And that's, lack of predictability makes people anxious, and it makes them much more reticent to sign on the dotted line because things could change at a moment's notice.
And do change on a moment.
Yeah, and so I think the other thing from managing a case and what can we do, at least as practitioners, to best position our clients to get the desired outcome. I think, financial statements have always been, I kind of call them the Bible of my case, right? I think we all know the importance of financial statements, but I always see them as almost the first point of advocacy for a client. Obviously, all the information needs to be accurate and complete, and disclosure needs to be, above board. But I think to be able to take the time, and sometimes it's a conversation with your client because they see this document and, this should be done in like an hour. It takes nothing. And to educate your client about the importance of taking the time to do this right and to help really frame your case, gain some credibility with the judge, don't be cute. Don't try to be fun, play funny with what you're disclosing. Let a judge know on page 1. I mean, I'm a fan of footnotes. So if you're listing income as 0, footnote it. How did your job loss come to be? What happened? Disclose the nature, extent, and composition of your severance package if you have one, right? Let the judge know if you are, if you own a business, right? Here's what last year's records showed, but I don't expect my 2020 income to be in line with 2019. And here's why, whether it's COVID related or not. I think that that's so important, and the impact of COVID and the pandemic, it's so important. I think the financial statements become that much more important. Not only to let the judge know and opposing counsel to know, what's on the table that needs to be resolved, but to also help frame your case to the judge. I think it's important.
I also think there's certain things like the one of the pieces that you don't have to take. You don't have to take a required minimum distribution this year. So if you're not taking
that's
it
a good
and
point.
it's not going to show up on your financial statement, footnote it. I footnotes, as somebody who uses them a lot but doesn't put them together, the more footnotes, the better from my perspective, to give me a better understanding of what this person's financial picture looks like.
I could not agree
Well,
more.
you can disclose accurately and still tell your story, right?
Yep.
Correct.
They're not
Correct.
mutually exclusive. And I think that's what Kristen's saying. You use that document to tell your client's story.
Absolutely.
And being
right.
cute, as Kristen was using the phrase, being cute or, only hurts on, not even on cross-examination. It hurts the credibility in front of the judge. And once that happens, right, you're always swimming upstream because
You're done. Yeah.
absolutely.
So you're saying don't put unknown in the dollar column.
I don't think it's helpful. I really do not think it's helpful because the judge is going to start asking questions, right? If you have unknown, undetermined, like, well, what have you been doing? Why are you even here that you have not done, right? I mean,
Right. Or give your best estimate
and you say it's an estimate.
Right.
Sure.
And then say what you did base it on. It may not be the determinative number, but at least give the judge some context as to where this number came from. Because when you don't do that, you get into hot water, and you're just creating problems that down the line will complicate the case, and with conflict comes cost. So educating your client that, the financial statement process is not fun. It's not easy. If you work with me, I'll probably drive you crazy, but I think it's an investment long-term in resolution of your case, credibility with your judge, framing the issues to the court, and frankly, doing it the right way. I mean, like, why, force someone to serve you discovery? Just disclose it. And then when they've reviewed the financial statement, if they have follow-up questions, I don't know, in a perfect world, send me an email. Let's see if we can resolve it, because
I do think
and motion to compel and the discovery can cost thousands of dollars.
And your financial statements, if we look back a year from now, the financial statements that are prepared this year, I'm guessing are going to look so different than the situation a year from now or whatever. And I think that it's going to be more important to rely on the footnotes and the, sort of the backstory behind it, because everybody's got a backstory on what's happening with them.
I think what Kristen just said about the severance is so important, because do not think, right, that the other side does not know that there was a severance. The other side always
know.
They always know. So just put it out there and get it right. And I also think counsel going or employing Susan, like something just to help with the financial statement in the very beginning, consulting with Susan or a colleague or an expert like her as to the required minimums, things like that we may not know because we don't use them that often. And there's all these changes and I can barely keep up with them. So, that's money well spent consulting. I'm not advertising for you, but it amazes me that more consultants aren't used early on with that financial statement, because that's all that matters is that financial statement.
It's funny, the expenses are the big one that comes to mind for me. And I know I've used Susan for help with that stuff before. I mean, you can have the client tell you what their balance is at their Bank of America checking account. It's like, that's the easy part. But Susan, what are some of the things that you do with clients to build up, to accurately portray the expenses? What are some of the tips you can give us?
Sure. I was actually, the first thing I was going to say was regarding the income. Most of your clients don't even understand their compensation. Wow. To the judge's point about complicated compensation, they do not understand it. So the first thing is, if they don't understand it, how are you as their attorney going to understand it? And you need to make sure that they do. I always say that the most popular like MCLE that I ever give is the one where we go through the pay stub and the W-2 and all that, because they're now so complicated. But in terms of expenses, I mean, clients, they don't know their income. Most clients, as you all know, don't know their income. I mean, their expenses either.
Nobody knows.
Nobody knows. They have no idea. So in terms of that, I start with where all of you start, which is trying to explain to them, giving them a list where they should start. But then we also go into other items that they may not be thinking of, or I mean, the expenses I find are more of a challenge getting people to really understand what it is you're looking for. Because do you want to know what my expenses are today? Or do you want to know what they're going to be like next year when I'm in my own home with 3 kids? So walking them through that is, can be a challenge. But the expenses, going back to what we were saying before, expenses today, I think the daycare is a perfect example. That you're not spending money on daycare today, but I think you need to make sure that if it's a 0 now, and if it's going to be a 0, I don't know, for the rest of the year, for 6 or 9 months, you have to footnote that, what you actually spent, footnote that, so everybody will remember. I don't know if a year from now, people are going to remember if you don't tell them why I didn't spend, what I normally spend $25,000 a year on childcare. Last year I spent 6, and this is why. So it's sort of a little bit of a different twist.
I mean, I wonder, I don't know how, I'm curious what you guys think, but I can't imagine a judge is going to get that upset if an entry about daycare is still on a financial statement You know, if I went to court tomorrow and I disclosed there was $800 a week of daycare, and the judge says, you know, the other lawyer rather says, well, there's no daycare today. I mean, I don't know that I would say that's, you know, a misleading financial statement. The fact that that's not zeroed out with a footnote. Am I wrong about that, Judge?
No, I don't think it's misleading, but I think to say we're not paying it now, but it's going to go back up to 800, or based on my 2019 income, it was 800, is one of those footnotes that are so important. I don't think it's misleading, but if you think about the amount of time, because as Kristen says, client comes in, you give them the form, and everybody they sort of gloss over on this form that they don't want to have to fill out, that they don't know how to fill out. You keep saying it's important, be forthright, be forthright. But by the time you get into court, even without COVID, things have changed. Somebody's moved to an apartment. There's nothing wrong with doing actual expenses now and projected expenses, because the house is going to be sold and I'm going to purchase. Having 2 on 1 or having 2 sheets of projected expenses is very important, because that's more of the needs that David's talking about. Not just your needs today, but what are the needs going to be after divorce? And so spending time and working on that is so important, not just COVID world, probably maybe a little more now, but all the time, because the expenses that they have on your initial financial statement are very different 18 to 24 months later if you're trying a case or your client's being cross-examined on it or in a deposition.
And if they don't know what they are today, they're sure going to need to know them when they're divorced, because they're going to have a budget to live on. So I always tell them this is a great place to start. Yes, this is what it is today. It won't look like what it's going to be later on, but you're going to need to know, and you need to have a starting place, because there is only so much to go around, whether you're the recipient or the payor. You need to know what you've got. And so many families don't, as we all know. So it's a really important place to start.
Judge, we're running out of time, but I didn't want to forget. Can you tell the audience about the conciliation program? Because I had asked you, this is actually how we met when I did one of these a few years ago. And it's such a great program.
So there's a couple of conciliation programs right now. One is that retired judges have volunteered their services to the courts. Not every county, and it's not necessarily that we wouldn't go to every county. We would go to every county. It's just that sitting judges or judicial case managers hasn't called upon us. But I know that you could, and I also know that every county does have a conciliation panel through the administrative office and ADR. So there's always conciliation panels where the lawyers volunteer their time. But now many retired judges, and I'm sure private attorney mediators as well, is doing it. So there's that conciliation program. But what David is speaking of, and I think that this is an incredibly important one now, because modification is not the whole case. Modification generally will be support or a parenting schedule, because people are home more, not home, the old parenting schedules, some because of COVID are having to be modified voluntarily or by court. But most counties have what they call limited issue settlement conferences, and either a judge tells you about it at a pretrial, or you can ask a judge. Both attorneys have to agree. It generally is 45 minutes of retired judge time. You know how long I take on
always
everything.
More. I've always gotten
all
more.
Of those who know me know that I can't do anything in 45 minutes. So I generally spend about 2 hours. We schedule like 3 or 4 cases when court was open. I'm sorry. This program's been around for the 6 years since I've been retired, or 5.5 years. So if it is a limited issue like child support modification, parenting schedule modification, those types of things, I would ask the judge when you're having a hearing, or even call into the judicial case manager or session clerk, if both attorneys agree, if David and Kristen have a case and they want it. So Jocelyn Welch, who used to work at the administrative office, manages it. she gets from the court has to assign you. And then Jocelyn calls the retired judges, and we do it once a month or twice a month, depending on where we need to go or where our availability. But judges will do these limited issues all the time. They're generally done in the courthouse. I'm sure now they could be done by Zoom. They're supposed to be limited issues. The enforceability of a prenuptial agreement is not a limited issue, but some people bring in something complex. They go, it's only one issue, Judge. And I go, yeah, but that's not exactly really. But I would take advantage of that, because I think that when two attorneys want it, why would not a judge send you to a limited issue conference? It's totally confidential. All I say at the end of my day when I'm doing limited issues, or the other retired judges, are yes or no. If you are able to settle, because oftentimes they're done in Norfolk, but they can be from many counties. It's not necessarily only Norfolk counties. Norfolk cases can go and be heard in Norfolk, can be have limited issues conferences in Norfolk. Many counties go to one place. Jocelyn gets the files, brings them, sends the relevant pleadings to the judge to review it before. So we have the financial statements, we have the pre-trials or whatever. All we say is thumbs up, thumbs down. But let's say you were a Suffolk case and we were doing it in Norfolk that day. A Norfolk judge will be designated, so you could get a judgment that day if you're able to settle. So you don't have to go back and go to Suffolk and wait in the queue till you can get your case
I
heard.
didn't realize that.
They're all designated they have been in Norfolk when I've sat there. I can't imagine that they're not in every county. So if I'm hearing a Middlesex case, or I'm mediating or conciliating a Middlesex case, but sitting in Norfolk or Suffolk, you can immediately get into a judge for a judgment. And I think that's really important, especially now when you're having trouble getting into court. So please take advantage of that. There's like 8 retired judges that do it. It comes out of the chief's office, but at least 8 retired judges are doing it. So please take advantage of it. We love to do it, and we do settle a lot of cases.
And do you think job loss recalculation is the type of issue that would fit the criteria?
I do. Yeah, I do. I mean, it's a modification, and I think the court would like some help getting, it's one issue. So fortunately, you're not doing a property division at the same time. You're not doing custody, although I've done many parenting schedules, if that's the issue. There are some legal issues like removal you can't do, right? I mean, there's certain issues.
What about contempts?
We've never done contempts. I would imagine my colleagues would not mind trying to settle them. Remember, it's only settling them,
Yeah, right.
not finding somebody in contempt or making a finding that there has been. But if people are willing to sit down and settle, why not? Absolutely. That's a little more tricky, because you're going to have the inability to pay, or the inability to perform on an agreement there already is, or a judgment that there already is. That might be a little trickier, but I would do it. I don't know why my colleagues wouldn't, if the attorneys come prepared, have their clients prepared. It's very informal. You sit at a table on the same level with them. We don't wear robes. I shouldn't speak for everybody. I don't wear a robe when I do it, but a lot of it's prep and getting the documents to Jocelyn, who gets them to the judge, because you want to go in and start. But the clients have to understand that they have 2 hours at no cost, and they can get a result that day. And it's even when I'm not, sometimes I'll come on like, I didn't settle any and I did 4 today. They eventually do settle. Maybe they're not ready to do it that day, but you give them some suggestions.
Mm-hmm.
And you give them a lot more time than a judge can do at a pretrial. You're able to give them a lot more time than a judge can at a pretrial.
Yeah, and even if you're not able to, settle the case per se, narrowing the issues in and of itself is helpful.
Yes,
It's
and
every
getting
way
even a
possible.
partial judgment, as Kristen said, just get a partial judgment and have the judge approve it. It's right.
Well, that's what I was gonna say. Sometimes there's 5 issues on a mod, but there's really only one issue that you have to crack, and the rest just, sort of
Going to
fall
fall into
aside.
place. Yeah.
Yeah, exactly. So that might be, can you do that? Can you isolate one issue in a 5-count modification to bring in? Or do you think a judge would look at it and say, wait, there's too many counts in your modification, forget about it?
As long as the conciliator judge is comfortable that once that is cracked and agreed to, that the rest is going to fall into place, sure, why not?
Well, I mean, can Kristen and I agree that, there's a modification with 5 different issues,
Mhm.
but we're just going to go to you as the conciliator for the support issue. And we're not going to deal with the custody issue that's on mod through the conciliation. Will we get rejected for making that request?
I don't think so. I
Okay,
think the
cool.
judges are very happy. There's not really there's a protocol that the sitting judges have received about referring, that
Mhm.
everybody has to want to do it, that they have to submit their documents a certain amount of time. But I don't think that any of the retired judges would not sit and help you with anything they could. Because if you get to the big one, right, we know you're going to settle the rest of it at some point.
Yeah.
After you're not with us. So I can't speak for my other 7 colleagues, but I know they're very anxious to do them and they work really hard at them. It's interesting.
Such a great
Hopefully they do
resource.
them quicker. Hopefully they do them quicker than me, but I take longer than anybody.
Well, it's 5 o'clock. Our hour is just about up. So I want to thank the 3 of you for joining me today. And this session will be recorded on YouTube. It'll go up on the website in a little while, and I'll post the panel's information so you know how to contact them. Thank you very much, everybody. I really
Thank you,
appreciate your
David.
time. Great information today. Talk to
Thank
you
you,
again
David.
soon.
Thank you,
Thanks.
David, for
Thank you,
doing
Judge.
this.
Thank you,
Yeah,
Susan.
thanks, David, for joining
Bye.
us.
Thanks, everybody.
Bye. Thanks.
Bye.
Bye.